Well, hey, everybody. Thank you for joining us for this presentation from the CBA of Colorado Employment Law and what has changed in 2021. Diana Fields is joining us with the Denver office of Kutak Rock LLP. Diana is a 30-plus year employment law attorney and assists CBA members with their HR and Colorado employment law questions through the CBA's HR and Employment Legal Hotline, which we launched. Diana and I were talking just under a year ago, so it's still a pretty new service, but it's a free service to all of our CBA members, and it was really crafted around the issues of a lot of questions coming in regarding PPP and SBA loans during the height of the pandemic. And I know, Diana, you've been flooded with plenty of questions throughout this last year. We've decided to continue the program through, I believe, the mid part of this year. And if we continue to see lots of use, we'll continue to utilize your excellent services. And thank you again for that. With the new year, though, Colorado also introduced new employment laws and changes to help us navigate through a lot of that and a lot of the questions we've also received about those new rules and changes. We've invited Diana to do a quick presentation today on those changes for 2021. What we'd like to do to set this up is we'll take questions in the chat window. Go ahead and pose them there. I'll go ahead and collect them, and then at the end we'll do a quick Q&A, and Diana can address each one of those questions individually. I'll be happy to present those back to you, Diana, to make it flow a little easier. So yes, please pose your questions in the chat window, and the slides today that you see from Diana will be placed on our website along with the recording that we just got set up of today's presentation. So with that, please welcome Diana Fields of Kutak Rock.
Thank you, Justin. And maybe we can say that one thing that is a little bit of procrastination or getting our schedules together, I think helped in this circumstance. Justin and I started talking about some of the impending changes in Colorado employment law that would take place January 1, 21. But I think what I have found is that, not only having the laws in place is what's important in understanding what it is, but really how as applied. So actually with the last 3 months, I think that just based on some of the questions I've gotten from clients, it's created additional insights into what these laws mean and how much we know or don't know or continue to hope to find out. So I think that this is timely, although some of this might be and hopefully is information that you are generally aware of. But again, I want to go over kind of the big picture, some of the new changes in Colorado, but how as applied, I have seen some questions and concerns coming up from different employer clients. And as Justin said, we started this with the whole pandemic. And as you know, for those of you who are actually directly involved in the employment law arena, we've all been drinking out of a fire hose because with all the mandated precautions and safety precautions, the leave aspects, and just how to treat employees from a safety standpoint, it's been a continually evolving situation, and I think that's probably still true today. So again, I want to touch on the highlights and then bring up some of the practical issues that I've seen in my practice in the last couple of months, particularly in Colorado, but we're going to end with talking about kind of big picture, what's on everybody's mind as people are getting more and more vaccines, some questions related to best practices to the extent we now know in terms of vaccinations. So one of the things that Justin and I were talking about is the slides I have prepared. They will come, you're welcome to take them afterwards, but there's some content that may be blocked if you've got full view for the speakers. So I would encourage you to go to the top of your video bar, and I'm actually going to do the same, which is hide video view, and then it'll just be a very small icon on your screen, so it won't block any of the content. So let's get started. So Colorado employment law, what has changed? So one of the first acts that you're probably all aware of is Colorado's Equal Pay for Equal Work Act and the related rules which were designed to implement these, which was the Equal Pay Transparency Rules. Well, the interesting thing for many of us who have been in the employment law area for a long time is there has always been in existence under Title VII and some of the federal acts that you cannot discriminate based on sex in terms of providing pay to people who are doing similar work. Well, Colorado implemented its own state law, and it actually goes beyond just the Equal Pay for Equal Work Act. So there's three components of it, which is addressing equal pay, talking about salary history, and talking about pay transparency. So we'll start with just the basics of the law. So the act prohibits paying different wages to employees who perform substantially similar work on the basis of sex or sex plus another protected status. So any of the others protected statuses that are in the Colorado Anti-Discrimination Act. So you've got to kind of break this down. What is substantially similar work? So this is identifying work that, regardless of job title, that you look at a composite of the skill that's required, the effort, which sometimes you may pay differentials because of the different shift work, but skill, effort, and responsibility. So again, so employees who are doing the substantially similar work are supposed to be paid the same regardless of sex. But a pay disparity is allowed where you can justify it entirely by one or more of what we consider non-discriminatory factors. So if a person of one particular sex is paid higher because of a seniority system, based on merit review, based on a system that measures earnings by quantity or quality of production. For example, if you have sales production and you're doing it based on objective factor. Sometimes you might have pay disparities because of the geographic location, because of higher cost of living. You can justify the pay disparity if you've got different levels of education, training, or experience. Someone's got an advanced degree that you feel like you need to pay more because of market competitiveness. And then again, if there's a disparity because one position requires travel as a regular part of the job duty. So this is all similar to what we all knew under the current status of some of the sex discrimination laws that were in effect at both the state level and the federal level. One of the things that was added to this Equal Pay for Equal Work Act is what they consider salary history prohibitions. And this is that you are no longer allowed to seek the wage rate history of any employees. For example, some employment applications said, list your prior salary. Or in an interview, you might ask a candidate, what were you paid in your prior position? So the idea is that rather than perpetuating historical wage discrimination that might have been in effect at the candidate's prior place of employment, you don't want to base your decisions based on just prior history, because the idea is that, historically, if women were underpaid and you ask them what they were paid before and you just continue to pay salary based on that you're never going to close the pay gap. So you're no longer allowed to ask about salary history or to make your wage decisions based on prior wage history. So then they've added some provisions that say you cannot discriminate or retaliate against somebody who refused to disclose their wage history. And then also you no longer can have any kind of company policies that might prohibit employees from talking about their wages. I just had this issue come up probably 2 weeks ago where an employer actually terminated an employee because in their policies said you cannot discuss your wages. And they had brought in an employer or a male employee who was being paid significantly more than the other female employees. The female employees then got upset. And so rather than changing the pay disparity, they actually fired the individual. Well, that would now be prohibited under this new Wage Act. And so that includes having some employers have required employees to sign, policies or agreements saying that they will agree not to disclose their wages. And just as an added note, that's always been prohibited under the National Labor Relations Act, which is an act that applies to union activity, but it also applies to non-unionized employers because it talks about the fact that employees have the right to discuss working conditions, things like wages. That is considered protected activity under the National Labor Relations Act. So this has just now been set out in Colorado statute. So the Equal Pay Act also now talks the different kind of damages. So if an employee were to sue you for pay disparity, saying that they have a substantially similar job to, let's say, for example, so a woman brings a claim, substantially similar job to a male, and brings a wage ed claim, she can try to recover wage differences for up to 3 years. On top of that, there's what's considered liquidated damages. And for those of you who are due wage and hour work, as you know, that's a common thing in kind of the wage area, which is like a punitive award, which is basically doubling the amount of back pay, unless the employer can show that it acted in good faith. And we're going to talk about this. So one of the things that a lot of you may have done, or if you haven't done it, it's still not too late, is it's like an affirmative defense to a claim that you were intentionally underpaying employees. And that is, if within 2 years of the date that you've been sued, you can show that you did a comprehensive pay audit of your workforce, but the audit has to be with the goal of 2 things. 1, identifying pay disparities, and 2, actually remedying any unlawful pay disparities that you've uncovered. So I've been doing a lot of that with some of my clients. And one, just as a practical note, one of the things you want to do, I mean, sometimes this comes up once you've been sued, to provide your defense, you want to do a pay disparity, you want to look at your different your different pay grades and determine if there's a disparity. But it's better to do it on a proactive basis now. But you may want to do that, you probably want to do this under the guidance of under the direction of an attorney, because then it can be covered under an attorney-client privilege. So at this point, because if you're doing it just proactively, that protects it from being disclosed unless you later choose to disclose it. So if you come up with information and it doesn't look good for you, then you can say that this was done at the direction of an attorney, and it's considered privileged. So that's one of the things you want to do. And we're going to talk a little bit later about what is some of the best practices to allow you to do a comprehensive pay audit. But so that can be a defense to this liquidated damages. Another thing that was added specifically in here, which again was under the Lilly Ledbetter Federal Act, but that each new paycheck is a new violation. And that's important because then that's what you look at for the statute of limitations in terms of when is it that somebody has to bring a claim. So a claimant can bring a claim with the Colorado Department of Labor within 1 year, or can bring a private action within 2 years. So if an employee is terminated, they would go from the date of the last paycheck. Some of the remedies can be reinstating the employee, promoting the employee, or if it's a current employee, to have a court order that would mandate a pay increase. An employee who brings this could be entitled to its court costs and attorney's fees. The third component of this act really is what we consider pay transparency. So again, the idea that to correct any historical wage discrimination between men and women, the idea again is that a lot of women may not have been aware that some of their male counterparts were being paid more than they were. So again, the idea is just as if everybody has complied with the law, then they can be transparent in terms of what the compensation is for each of the jobs. And so these next 2 issues are really what I've found a lot of employers kind of struggling with. So to begin with, if you are going to post a job externally, now in Colorado, if you're going to post a job, you have to show the hourly rate or salary compensation. You can put a range, but it has to be a good faith range. For example, in some of the regulations, they talk about you can't say we're hiring from this position, it's from 30,000 to 100,000. It's got to be a good faith range. And there can be instances where you depart from the range advertised. For example, if you get a candidate who has unusual experience and you can justify going a little bit higher than what you've advertised. But really, you've got to make a good faith effort to show what the salary range is. The salary includes any bonuses, commissions, or other forms of compensation. So you would put in there that, this position is eligible for a bonus of, and you can describe the bonus. You don't have to actually put the amount. Is eligible for overtime, because that's, again, one of the issues is that In certain, depending on the manager, a claim of wage discrimination could come up because it'd say that employees of a certain sex have more opportunity to have overtime and the ability to increase compensation. You need to, again, do a general description of all of the employee benefits, which is paid time off, healthcare. Again, not a dollar amount, but just so people know what it is you're offering for this position. So none of this is hidden. Now, this is the area where I've had a lot of calls and concerns, is internal postings. So the Act talks about promotional opportunities. So before you are going to promote an employee, you have to internally post to all of your employees the job position that's available. So the Act requires reasonable efforts to post opportunities for promotion to all current employees on the same calendar day and prior to making the employment decision. So the issue comes up is, what is a promotional opportunity? It says that if it exists, if an employer has or anticipates a vacancy in an existing position. So for example, you have a senior level manager who retires. Well, you know that there's a vacancy there, so you need to post that. If it's a new position, you decide you need to have 2 directors of marketing. You're creating a new position, you have to post it. And the standard is, if it's a promotional opportunity, if it would be considered a promotion for 1 or more employees in your workforce in terms of compensation, benefits, status, duties, or access to further advancement. So it can be, even if it's not a pay increase, but if it's at a trajectory that might get somebody to a senior level management position, just the access to further advancement could be deemed a promotion. So there was some uncertainty about, what this means in terms of if it's so existing and new position, seem pretty clear. But at the end of the year, the Colorado Department of Labor issued a bulletin, and I don't know if you are all familiar, but it's a good thing to be familiar with. Go to the Colorado Department of Labor website, and they've got a tab there for all of their bulletins. And so it's an interpretive bulletin from the Colorado Department of Labor. It doesn't really have the force and effect of law, but because the agency is empowered with enforcing the law, it certainly has some persuasive authority, because they're the agency that's going to be enforcing it. So they came up with a bulletin that really kind of expanded what many of us were thinking about what constituted a vacancy. So again, so what is a vacancy? A vacancy exists when you're backfilling an existing position. That's pretty clear. When you're adding a new position, again, that's pretty clear. Or, and this is the one that I've had a lot of employers have some trouble with, when you're giving an existing employee a new position, including by changing their title or materially changing their authority, duties, or opportunities. So some of the employers that I've talked to have talked about this as kind of an inline promotion. You've already got an employee that you want to advance to another position, and you don't, in your mind, you're not really creating a new position. In some circumstances, it might not be backfilling an existing position, but if it gives this employee materially different authority, duties, and opportunities, the Colorado Department of Labor says that you must post this position. So it says, again, this is some of the language from the bulletin. You're going to want to look this up, but a vacancy in a new position thus includes a lateral job change or a promotion along a fixed inline career trajectory for which a current employee is eligible. There are a lot of examples given in that bulletin. So they talk about, for example, when they talk about a fixed inline career trajectory, if you're advancing an employee from engineer 1 to engineer 2, do you actually have to post that? And the Colorado Department of Labor says yes. Now the posting has to be made by a method that all employees can access on the same day. So again, in this time of COVID, where we're still working at home in part, or some in the facility, you have to make sure that it's available to everybody at the same time. And so, rather than just posting it in the lunchroom or something, you have to make sure that it's available to people online. It has to include the same things that you would put in an external posting. So job title, compensation and benefits, telling employees how they may apply for the position, and you must notify all the employees, not just ones you think might be eligible. And it's got to be reasonably in advance to allow employees to apply. I had an employer call the other day where they had already decided to fill a vacancy, had been working with the senior manager. They said it's not really a new job because we're not going to backfill. In that case, it was a woman. We're not going to backfill her job, but we're going to just promote her to this new position. And I said, that's one that needs to be posted internally. And so they were talking about, because they had already talked to this person about the position, can they just post it for a couple of days and call it good? And, really, I think what you need to do is you've got to show good faith effort to comply with this, make it accessible, and really make no decisions until everybody's had the opportunity to apply for it. So there's exceptions to this act if the job, you're a Colorado employer, but the job is to be performed outside of Colorado, you don't need to post the compensation. Or if you're posting outside of Colorado for a job, those non-Colorado residents don't need to have the same requirements. So there are exceptions. If there's an employee in a position who doesn't yet know that they're going to be separated, but if you have already identified some candidates who might be eligible for the job, you can't just tell the one candidate. You need to notify anybody who meets the minimum qualifications for the job and anybody who has a substantially similar job to the employee being told. You don't have to publish if there's an automatic promotion after a trial period of 1 year. So when an employee is hired, if in writing you have said, so long as you successfully perform your job, within 1 year, you will automatically be promoted to a certain position. Or if it's part of an employee handbook, again, this is for people who are going through a kind of an online trajectory, but as long as that's a 1 year period and it's in writing, that does not have to be published internally. And then also if it's just a temporary, you've got an immediate vacancy and you have to put someone in it for less than 6 months, that does not have to be published. But once it becomes a permanent job, you do need to have the posting internally. So some of the things that you may want to do is just action items here. Make sure you review your job applications, take off any requests for prior salary. Make sure that who's doing the interview doesn't ask questions about prior salary. You're going to want to update job descriptions, because if you get sued, you want to know, what are the substantially similar jobs. And it's not always job title. So if you want to, that'll help you identify what are substantially similar positions. I worked with some employers who will group, because they may not have more than 1 or 2 people in a job title, but they will group them by either title, by grade, pay grades, or work groups. Just again, so you have in advance what are substantially similar jobs. You want to come up with your pay philosophy. How do you pay? Is it based on merit? Is it based on seniority? How do you determine rates for new hires? How do you determine rates for when you're giving salary increases? Just so you got that down in writing and it's objective. And if it's based on the 6 factors that we talked about earlier, which are allowed by the law, then you can justify that these are non-discriminatory reasons that are pay differentials. If you want to take advantage of the affirmative defense, if you were to get sued, you can go ahead and conduct a pay equity analysis. And it can be simple, or it could, depending on the size of your workforce. Some of the employers I've worked with are doing it internally. Others, they're large enough that they actually, again, through our law firm, is to make sure it's attorney-client privilege. I have engaged outside HR professionals who come in and, they've got this down and they ask for the information they need. They do the statistical analysis. And in what I'm doing right now, they've identified potential pay disparities where there's a plus or minus 10% difference in wage differentials. And because this Pay Equity Act says you cannot discriminate based on sex or sex plus any other factor, in the one that I'm doing now, we're doing it both based on gender and age, just to determine what if there are any disparities. So again, while you're doing a pay equity analysis, because it requires both identifying pay disparities and remedying it, you've got to talk to senior management and to determine your ability to remedy any pay disparities. Not everyone is going to be able to, make the adjustments that are required. And when you're doing a pay equity audit, you never want to uh, basically deduct pay from certain, let's say for the example, if men were overpaid in a particular group, you don't want to deduct their wages, but rather you'd want to increase the wages of the people that you've identified as having the pay disparity. And you may not want to do it just off the cuff. You could do it with your regular, your annual salary review, or, some kind of anniversary that would be meaningful to you. But again, you might need to, if you're not able to correct all the pay disparities identified, determine the priority on an objective manner, how you would correct any pay disparities identified. So again, if the pay disparity is not explained by one or more of the 6 factors, make the adjustments. You want to train your managers and the hiring personnel on the salary history issues and pay practices. So when they're recommending raises based on performance reviews, that you're, again, not using any kind of historical discriminatory factors in making pay raises. Develop your policies for posting new hires or promotional opportunities. I don't think a lot of the line managers are aware of the fact that some of these promotions need to be publicized internally before they're done. So just make sure everybody's up to date on that, and then make sure you keep the records. Okay, the next act that I'm sure that many of you have already had to comply with is the Colorado Healthy Families and Workplaces Act, because there was a component of it that existed before January 2021. So I'm just going to talk about what went into effect January 2021. The Healthy Families and Workplaces Act had 2 kinds of leave: paid sick and safe leave, and then what they call public health emergency leave. So the paid sick and safe leave, as you probably know, January 1 applied to any employers with 15 or more employees, and it won't go into effect for smaller employers until next year. And this requires 1 hour for every 30 hours worked, up to 48 hours, starting immediately for any 5 of these categories. I'm not going to go through them in detail because you're probably familiar with it, but illnesses, preventative care. This is kind of new, is victim of domestic abuse, sexual assault, or criminal harassment, caring for a family member who has any of the above. And then due to what we're all familiar with, is due to a public health emergency if your place of business or school is closed. So one of the issues that, for those of you who already have this in place, you may have already struggled with this, or for people, the smaller employers, the issue comes up with how do you incorporate these new requirements with your existing paid leave policies. And so for those who had separate vacation banks versus sick leave banks, if you had the sick leave one, it was easier. But where I've seen a lot of the employers struggle is with where they've had a combined PTO bank. So it's unspecified, right? You can take it for sick leave, you can take it for vacation. The employer is not going to ask. So the one thing that you're going to want to review with your legal counsel is to make sure that you're still complying. If you're going to say the existing PTO policy is designed to comply with this act, you've got to make sure that it does. For example, some of the issues were that I've had clients who said that you can accrue PTO hours up to a certain amount and then you don't accrue anymore. Well, the law actually requires accrual every year, 1 hour for every 30 hours worked. And so far the interpretation is that you have to continue to accrue at least 48 hours. So you can't cap the accrual, even if you currently have that under your existing PTO policy. This, hopefully everybody is aware of this, is the supplemental public health emergency leave. When this first came out, we all thought, oh, Colorado is just taking the experience we had with COVID and anticipating the next pandemic. And most of you probably know that late December, Colorado Department of Labor issued an opinion that was a surprise to almost all of us, which is they said that although the COVID-19 pandemic had been declared earlier, they were considering the pandemic, the COVID-19, as an existing public health emergency that would require this emergency leave. And it would require it for all employers, regardless of size. So if you're a smaller employer and you weren't yet required to provide the paid sick leave, then you still had to provide this emergency public health emergency leave, which is up to 80 hours. And again, the way that the statute was designed, it was supposed to be that if you were obligated under the paid sick and safe time leave to provide paid leave to employees, you only had to supplement any accrued leave up to 80 hours for this public health emergency leave. Well, because this Colorado Department of Labor said this applied January 1, nobody had yet accrued any of the state mandated public health or none of the state sick leave. So January 1, you had to have 80 hours, let's talk about here, if it was an employee working less than 80 hours, it was a proportion of how much they worked. But the public health emergency leave was similar to what was under some of the federal acts that were issued under the administration at the federal level due to COVID. And so it was 80 hours until 4 weeks after the end of the public health emergency. So far, the public health emergency is still outstanding, and there has not been a declaration of that it's ended for any of the following purposes. And again, this was similar to some of the federal, that if you were diagnosed with symptoms, so currently it's COVID-19, if you're seeking treatment, if your office was closed, or you were asked to quarantine due to exposure. Number 4 here is different than what was in the Federal Act, which was you were being unable to work due to a health condition that may increase the susceptibility or risk of such an illness. So the fact that you had some kind of pre-existing condition that might make you more susceptible to severe illness under COVID-19, that would entitle you to leave up to 80 hours. And then again, this number 5, which was caring for a child if there was a closure of a school or child care provider. So just one thing that's important to know, that for this public health emergency, COVID-19, you can only use the 80 hours once. If it's not used, then it expires. And the other thing that was important is that even if you provided COVID-related leave to an employee in 2020, the 80 hours is required to start all over again for 2021. Another open issue that I've had some employers ask about is, you may be aware that under some of the federal tax act, like the Rescue Act, has now extended some of the federal requirements for this paid leave. And it says if an employer is going to voluntarily provide leave similar to what was mandated, you can get a tax credit. Well, there's an open issue, and I keep looking for guidance, because this is, is an employer actually voluntarily providing this leave if it's required to do so under state law? I've had some employers say that they're going to track it, and hopefully by the time they have to file their tax returns, there may be more clarity on that issue. But so far, I have not seen any guidance on that, whether you can claim a tax credit under the federal law, because the federal language really says if you're voluntarily providing it, and here the state is mandating it. But so that's another thing that hopefully there'll be some clarity on. This one I'll just go over very quickly, that I'm sure you're all aware of, is the new federal, or the new state overtime and minimum pay standards order, just increasing the minimum pay, confirming that it's overtime is 40 hours in a work week, 12 hours in a work day, or 12 consecutive hours if it overlaps from one day to the next. It's increased the salary exemption for some of your employees who are exempt employees. And then one thing that was key is that they have now adopted the definition of employer that is found in the Fair Labor Standards Act. And this is because there was a Colorado Supreme Court opinion that kind of put into question this. And this is that expands the definition of employer to individuals, which they said that are acting directly or indirectly in the interest of an employer in relation to an employee. So what this means is that individuals can have liability. So that would be potentially the executives who are setting, who know the pay practices of the company. It can be potentially HR people or others who are making decisions about the salaries of employees. If they are, underpaid. So this is looking into the future. As you all know, that the legislature had, for a couple of years, have been trying to pass a state family and medical leave act, a state equivalent to what's applied at the federal level. It never passed, so they put it to the voters, and Proposition 118 was passed. We've got some runway there because it's not going to take effect, but this is going to create paid family medical leave obligations for employers in the state. It's going to be like your unemployment insurance, so it's going to be taxed based on your rate of pay to your employees. It says starting January 1st, 2023, it's going to be a 0.9% tax. It's going to be split equally between the employee and the employer. Unless you're a smaller employee, you don't actually have to pay the employer portion. So they're going to start collecting the insurance tax, and it's going to take effect not until January 2024. This I just listed again. I think I just read this morning that this is proposed legislation that called the Protecting Opportunities and Workers' Rights Act, the POWER Act, that is changing some of the the laws on discrimination and unfair employment practices. I read that it just came out of the House committees and is now in the Senate. So I have no idea if this is actually going to pass, but I just wanted to make you aware of this, something to look at. It's going to talk about some of the procedures for administrative proceedings. Right now, the language is going to cover independent contractors, subcontractors, and their employees, and even volunteers. In terms of discrimination, it's going to include marital status or caregiver status in protected classes, talking about if an employer fails to investigate and remedy discrimination, that's a violation of the act. Some prohibitions on pre-employment examinations, and expanding the time to file charges with the state Colorado Department of Labor from 6 months to 300 days. So it's similar to if somebody were to file something with the EEOC, which is a 300 days. So again, this may be changed. It may never come out of the Senate, but just something to be aware of. So final thing that I wanted to conclude with is regarding COVID vaccines. Again, hopefully many of us have been vaccinated. I get my second shot tomorrow. But originally I had titled this, Can Employers Mandate Employees to Get Vaccinated? And we'll talk about that next. But there still is uncertainty on that. So can you urge employees to get vaccinated? The answer is yes, if you can say it's job related and consistent with business necessity. Again, because you're incented to try to make sure you've got a safe workplace for employees, you can urge employees to get it. But you have to be aware that not all employees may be able to get it, either because they've got a disability or because they may claim it violates a sincerely held religious belief. So as you know, the Americans with Disabilities Act, if you were to ask or talk about the vaccines, you need to reasonably accommodate someone who has a disability if they've got a physical condition that they're not able to get vaccinated, unless the accommodation would create an undue hardship. Title VII is what talks about the religious discrimination, and there's really a big issue, and Colorado law is pretty liberal on this in terms of what is considered a religious belief. So again, that could be something to question whether somebody claims that they're doing this because they have a religious belief that prevents vaccinations. So early on, the advice was, can an employer mandate vaccines? And I think a lot of people were saying, yes, you can mandate it, because there's some EEOC guidance that suggested that mandatory vaccination is lawful. As you know, when we've looked at COVID, there have been quite a few relaxations on things that might have been previously considered medical inquiries, such as taking temperatures, screening for medical conditions. And I think the idea was there was a relaxation because we were in the middle of a pandemic. There has recently been some pushback, though, on terms of whether employers really want to go the step of saying this is mandated. Number one, I have a lot of employers who say, well, if we mandate it and people won't get vaccinated, we have a hard time finding employees. So, what do we do? Do we fire them if they wouldn't get it? And so that's an issue, right? If you don't have the workforce, it's hard to mandate it. because you'd have to follow through and say, well, if you don't have one of these exceptions, a religious belief or a disability, and you're just refusing to get it for political reasons, are you really willing to fire the person? Most of my clients have chosen not to do mandatory. And then recently there's been some lawsuits filed that said that because the vaccines were only approved under the emergency use authorization, if you look at the federal language on that, it says that people must be informed of the option to accept or refuse administration of the product, the consequences, if any, of refusing administration of the product. And so lawyers have taken that language and saying if an employer mandates it, it's violating the emergency use authorization language because it's mandating something that the EUA actually says is not even allowed. So some of the things to consider again as to whether you mandate it is, you've got all these countervailing issues because under OSHA, the Occupational Safety and Health Act, you've got a general duty to provide a workplace free from hazards, that are causing or likely to cause death or serious physical harm. So I know that some of the employers in the healthcare industry in particular are very concerned about, whether they need to mandate it or not. Again, this applies even for non-unionized employees, the National Labor Relations Act, because if you had employees who were, collectively discussing workplace considerations, like whether it was improper for an employer to mandate vaccinations and they were protesting it, that might be considered protected activity because it would, they would be under the National Labor Relations Act, they are free to discuss working conditions. I've seen some indication that an employee, if you were to somehow take some kind of disciplinary action against an employee who was protesting vaccinations, you just got to be concerned about, there's a Colorado lawful off-duty conduct statute that you're probably all aware of that was originally designed, actually was promoted by the smokers, by people who smoked cigarettes, that employers couldn't discriminate against employees who smoked if it was conduct that was lawful and off-duty, but that could be an issue that is raised. And then also one of the more recent laws that went into effect again at the beginning of the year is the Colorado Public Health Emergency Whistleblower Law, which was enacted in the time of COVID that allowed employees to raise reasonable concerns about workplace violations of government health or safety or significant workplace health or safety threats. So to the extent you took any action based upon, a person's either protest of a vaccination or trying to rally or get an employer to have a vaccinated workforce, just be aware of that there's whistleblower laws that come into effect if you took any kind of retaliatory action. So this is some of the issues that come up, and we can see this through when some of the employers had mandatory flu vaccinations, so mandatory versus voluntary vaccinations. So some courts have held that if an employer is requiring employees to be vaccinated, if you require them, that if the employee has any complications, that could be considered covered injury under the workers' compensation laws. And then there are other courts that have been split. If it's just voluntary but encouraged, some courts have held that maybe it could be considered workers' comp. Others have said, no, this is not, it was only voluntary, so there can be no workers' compensation liability. Again, that's to be determined, I suppose, as we get through the litigation on some of these issues. I've had some employers ask about whether to make it easy for their employees, they have provided the vaccinations on site. And they asked if it's a better practice to do it on site or should they reimburse employees who do it off site. So when you're doing it on site, one thing to consider is that before you receive the vaccine, that there may be some screening questions. So the fact that you're screening, it could elicit information about a disability. And so just be cautious that if you're doing it on site, you need to treat the information, even if it's a third party on site, just any information that is obtained, keep it confidential like any other information that you would receive. You might also want to make the option of employees to have the vaccination offsite if they have a concern about confidentiality. Do employers still need to require safety measures such as social distancing and face masks once everybody has been fully vaccinated? The answer so far is yes. And again, we might have different guidance. And I hope that everybody continues to monitor that from the CDC, from our state agencies, from your county health agency. But currently, it still would be best practices to maintain the current COVID safety protocols. Question is asking or requiring an employee to show proof that they've received the vaccine, is that a disability related inquiry? The EEOC has said no, because there could be non-disability related reasons not to get a vaccine. So if you're not mandated, you can ask for proof of the vaccine, and you might want to just tell employees, but don't provide any medical information. So you don't want someone to say, no, I didn't get it because I can't, because I have, I'm undergoing chemotherapy or something. I don't even know if that's a disqualifying condition, but something like that. So I know I've had some employers say they want to request it because they wanted to consider what percentage of the employees had been vaccinated. So that will kind of guide what kind of safety measures they're going to have to take on an ongoing basis. And again, that might be something that's dictated by the county. For example, if there's a certain percentage of vaccinated, like as you probably all know, that there's some CDC guidance that said that you can meet in small groups if everybody's fully vaccinated. So there may be additional guidance on that issue. So that would be the reason you might want to require if they got it someplace outside of the workplace. Another issue that's come up is if, again, you want to urge but not require your employees to get vaccinated, can you give some kind of incentive? I have seen people provide, I think it's mostly been like $150, including the paid time to go get the vaccination. But so payments might include cash, bonuses, gift cards. Some people I've heard are being very creative. Maybe additional paid time off or something subsidizing your health insurance. But one of the issues, of course, all lawyers, one of the issues is if you do that kind of incentive plan, there are some recent guidelines that talk about whether they could be considered a wellness program. And there are some requirements under federal law, under HIPAA, protecting public or private health information, under GINA, which is the Genetic Information Non-Discrimination Act, that could be affected depending on how you provide the incentives. I think under both of those, if it's just a de minimis payment, it's probably would be an exception. But I know that at the beginning of the year, there was some guidance that said there may be additional guidance issued under what might be considered a wellness plan if you offer an incentive. So another issue comes up though, if you're offering an incentive and there are some employees who aren't able to get the vaccine, is it discriminatory because they're not able to because of disability or religious reasons? So one employer I work with has done, I think it was $150 for getting the vaccination. And for those who were not able to due to disability or religious reasons, they had some additional COVID safety training. And as long as the employee listen to the video and attend some of the training, they also were given the incentive. So again, just trying to take whatever steps you can to make the workplace as safe as possible. And that is it. So if there are any questions, no, it looks like we've got about 8 minutes here.
Excellent. Thank you, Diana. We did get
Sure.
one question. Anne asked, how does overtime pay work in the event one is a salaried employee?
All right, so if an employee is salaried and they meet the, I did just a big picture, but you have to meet both the salary threshold as well as the tests that would make you exempt and the ones I gave were the executive, administrative, or professional, and it's based on basically being able to use independent discretion. So there are specific standards under both federal law and the state law. And so in those circumstances, that's the idea, is that you're exempt. So as long as you're meeting that salary threshold and you have the duties that meet the definition, then you don't pay any overtime. You're exempt from the overtime requirements.
Excellent. And hopefully that answers your question. And we've gotten some very nice compliments on this presentation, Diana. So thank you very much. We we'll make sure that both this webinar recording, which according to the button down below says it is, we'll make sure it gets posted. And then Diana, you'll share your slides with me and we'll put that on our website. And then we'll email everybody who registered for today's webinar with a link to that once it's posted to our website. So if there's no other questions, and I'm seeing everybody in the chat window is just saying thanks and great job and wonderful, Diana. And I think this is your inaugural webinar with us, so I
That's
have
right.
a feeling we'll be doing much more of this, right? So
Sure, yeah, and unfortunately, well, with our just the composition of our state, legislature and the governor, and I'm sure there's and at the federal level too. I mean, we're
right.
expecting a lot of changes in the employment area. So yes, wait, it's all TBD to be determined. There may be additional changes. So
Absolutely.
um,
Absolutely. Well, Diana, thank you very much for your time. And I'll just remind everybody again that we do have a HR and employment legal hotline. It works a lot like our FCC legal hotline. If you have a question, obviously in a more general sense about a situation, you send an email to us through our website, and I can get that link out to everybody when we send them the deck and link for this webinar. But that's always available to the CBA members. It's a free service. It works just like our FCC legal hotline. The only difference is instead of our FCC Fletcher Hilton Hildreth law firm, it's Diana here who's answering your questions. And we did that purposefully because we needed a Colorado attorney who understands Colorado employment law, because the timing on this couldn't have been more perfect with the amount of new rules and changes that we faced in 2021. So, Diana,
yeah,
thanks
and
again for your time.
sure. And one of the things I was going to say is just because we're a national firm, and we've got I think over 800 lawyers, but we provide a lot of updates. For example, under the thing on the wellness program, that's a peculiar issue for our employee benefits group. So what I will try to do and do a better job of is make sure I get those to Justin and he can post those. They're also accessible on our websites, but we have a big group in DC that's always following the federal legislation. And I know that we also often do client alerts that discuss, what's the latest under some of these new tax laws that are being passed. And again, we expect a lot of new changes in Washington, so I'll try to keep that up to date for you, Justin. If so, that may expand beyond employment, but you can choose what you want to post.
Sounds good. And we do occasionally update. We have a page dedicated to your bulletins and Kutak Rock when they put out new bulletins that you share with me. So, you know what? That's another thing we can include in that email when we send it out to the members. And that's up on our CBA website as well, coloradobroadcasters.org, if you want to race over there and check it out. I think we've got about 5 or 6 links that you've provided in probably the last 6 months as new rules were forming and changing so rapidly. So,
Right. Okay,
wonderful.
great. All right. Well, thank
Thanks
you.
again,
Thank you for
Diana.
having me.